Appeals Division 1 is now in session.
Please be seated. Good afternoon. We're here today for oral argument in the special action Trinh, I may be mispronouncing that, I hope not, versus Garcia, Real Party and Interest, State of Arizona. Our case number 1CA-SA 20-0244. Thank you all for coming this afternoon, and thank you for letting us reschedule. A couple weeks ago I had a scheduling conflict, and I appreciate you guys being flexible and allowing us to change the dates. As you all know, we record our oral arguments for YouTube, and we also, I think, stream it live for open courts. So please make sure you identify your client and who you are when you get up or when you speak there at the microphone. As a COVID, you're obviously welcome to stay, or you are required to stay at council chambers instead of using the lectern. We have conferenced this case. We have reviewed your briefs and the record. So we're relatively familiar with the facts of the case and your arguments. Please keep that in mind when you're making your arguments today. Petitioner, if you wish to reserve time, you are free to do so, but we'll ask you to keep track of that yourself. So we generally don't police that for you. Is there anything I've left off? I think I've covered it all. All right, with that, you may begin.
Good afternoon. Lynn Carey and Andrew Brevington for Petitioner Chung Trinh, who's in the gallery. May it please the court. In this case, defendant made a proper, specific request for the prosecutor to present a packet of information to the grand jury for its consideration. The Harold Trebus letter laid out exactly why the information was exculpatory and constituted what Harrell and Bashir cases have both called the defendant's version of the relevant substantive facts. ARS 21-412 specifically requires that the grand jury be informed that the defendant has information to present. Otherwise, the grand jury cannot exercise its control under the statute to determine whether it wants to hear that information. Instead of following the case law, the state instead usurped the independent role of the grand jury and presented only a few items from the Harold Trebus letter.
Counsel?
Yes.
Is there any limitation on what a target of a grand jury can put in such a letter?
I would suggest that Meritech, which is the most recent of the three, Trebus-Harrell, which were companion cases, and Meritech, it draws the line at the right of the grand jury to hear all relevant, non-protected evidence. That was the other Supreme Court case that we have guidance from. It was 6 years after Harold Trebus. So I would suggest that that would be the basis, which is all relevant, non-protected evidence. It doesn't mean that that anything can be thrown in the letter. I think the idea is it still needs to be, is it necessary for a determination of probable cause? But if you read the cases and synthesize all of them, they speak to the idea that the only way a defendant can participate is either through presenting a Harold Trebus letter or appearing and testifying. And so I think there should be some leeway. And I think the reality is that the trial court has the ability to look at an item and say, this would not advance the ball. An example is in Black.
Well, but just so a prosecutor gets a letter, and the prosecutor reviews the letter, and he or she believes that there's something in the letter that's objectionable. And I'll give you a hypothetical. So the prosecutor reads the letter, and it's a sexual assault case. And in the letter, there is a statement about the reputation for promiscuity by the victim. Now, that's not protected. She may have something, or he may have something on Facebook that says, I'm promiscuous. So it's not protected. It's arguably relevant. It goes to his state of mind. Does it come in? Does the prosecutor have to give that statement?
I think that if it would otherwise come into a trial setting, for instance, then I think it should be permitted. I think that the idea behind Harold Trebus, though, is that it is an initial stage. It is a determination of probable cause. And I think that Meritech needs to be our guide, which is to ensure that the grand jury is fully informed.
Well,
And so
so is your position that they would have to present that evidence?
I think that if a prosecutor could opt not to present the evidence, but
Oh,
it certainly would
okay,
be,
all right,
it would
all right.
certainly be subject to a motion for remand. An example is polygraphs. We have polygraphs. There are a lot of instances where polygraphs are not admissible in court. I think if to play this out, if a prosecutor said, I'm not going to submit a polygraph, and then defense files a motion for remand, I think that certainly there could be discussion of, is this appropriate under the circumstances? It's not a hard and fast.
So admissibility then would be
I
kind
think
of a
admissibility is a
guidepost.
component. I think admissibility would be a component of it. Keep in mind, we're in probable cause space, and the rules of evidence are typically relaxed for determinations of probable cause. So I do think things beyond the basics of admissibility, but it could provide a guide. I think the issue is in this case, where things got muddled is this idea of clearly exculpatory versus exculpatory. And that's what created the problem in this case, even though we have two cases that specifically say clearly exculpatory evidence is only a term used when the prosecutor has something, he must present it even if the defense does not request that evidence be presented. And I would suggest that the court review Bashir at paragraphs 9 and 10 and Black at paragraphs 12 and 13. And the reason I bring your attention to those is those cases in both of those paragraphs specifically explain what clearly exculpatory means. They rejected...
Hold on, because
Sure.
I don't want to get too far afield before I focus you back on a question that I had. In this case, one of the items that you allege in the letter that the prosecutor didn't present or even outline for the grand jury, as I understand it, was what I'll refer to as impeachment evidence about the credibility of some of the witnesses or motive for some of the witnesses to not be particularly forthcoming in their assessment of the defendant. But we don't let the grand jury decide credibility issues.
Well, I would...
So why is it may be totally relevant for the petite jury, but it's not really admissible per se for the grand jurors because it's simply not relevant to their determination, is it?
Well, let me pick an item, for instance. There were instances, and there were instances where the victim, the family victims, signed a informed consent to treat that specifically told them who their doctors were, specifically told them who would be treating them. The father worked on the website and specifically input the credentials of the defendant here. There were explanations of benefits that came out that specifically designated who the doctor was. I would submit that it is incredibly relevant and it is necessary to provide the defendant's position, not to impeach these individuals, but to say that they had notice. There was actual notice in front of them, and so it is exculpatory. Someone coming in with notice, it is not reasonable that they believed that the doctor or that Mr. Trinh was there in a medical or in a doctor position. And so the reality, though, is that one, I think that is exculpatory because of the nature of the fact that it so many times re-identifies for them exactly who the doctor is in the case. The beauty of it, though, is that what the grand jury needs to be able to do is know that that evidence is there. And it doesn't need to have every single item or every single component of that. It needs the subject and outline, which is the term that is used in the Bashir case. They need to be presented with the subject and outline of the testimony. And then it is the grand jury who gets to decide whether or not they accept and hear that evidence or reject it. What happened in this case is that the prosecutor instead weaved certain components of the Harold Trebus letter into Agent Hemp's testimony. The reason that's a problem is that is the third option that the Just case, which is the predecessor to Harold Trebus, specifically says you may not do. It specifically says when you summarize from your point of view as the prosecutor or as the agent, the case agent, you take the ability for the grand jury making a decision. You take it away from them. And they used the strongest language that I have seen in relation to due process. And I think it's important for us to look at that. The court in Just said that when you summarize information and you take it from the point of view of the prosecutor, you destroy the defendant's substantive procedural right to have a grand jury make an independent and uninfluenced decision. Trebus itself says taking away the notice from a grand jury is the same as predetermining the resolution of the grand jury proceeding. That's why it's so critical. And this is why the court does not need to actually get into, if it chose not to, some of these questions about, well, what's exculpatory, what's not exculpatory, what's the standard, is it the new Meritech standard of substantive, or is it exculpatory? The reason you don't have to go there is as soon as the prosecutor's office failed to put the grand jury on notice about anything that the defendant wanted to present and failed to attribute it to the defendant, at that point they violated the Just case. And the court can essentially stop its analysis at that point. That is sufficient for a remand.
Except we review these cases for harmless error.
Well, here's...
And how, just because the prosecutor in this case may not have given the magic word, if we review, it's otherwise a foregone conclusion that the indictment was going to issue.
I would say that this is not that case. And I'm sorry I stepped on you earlier. I can't see without the mask. So this is in Bashir. Bashir was an 11-1. This was an 11-1. There was one grand juror who, even though there was a defective presentation, still voted against a true bill. And what I would say here is...
Mr. Carey, I've been around long enough to know that having a dissenting grand juror doesn't really mean that much.
Well, I would submit, though, that there's no way we can know. Had the prosecutor come to the grand jury and said, there's a Harold Trebus letter, it covers these areas, do you want to hear that information? It could have convinced someone, and we won't know. The burden is very high here for the state to preserve its presentation. Under the cases, it specifically states that you have to remand unless we are sure beyond a reasonable doubt that the failure to present didn't influence it. Here we have an 11-1, just like Bashir. Here we have items that are exculpatory or under Meritech are substantive and provide a defendant's version of relative substantive facts, and it was not presented. The burden is high, and the burden is high because of the independence of the grand jury. And so I would submit that we do have to remand. It's no influence. They have to show that there's beyond a reasonable doubt that there was no influence on a jury's judgment. In this case, the grand jury didn't even know that...
We still have to apply that in the context of the low standard for probable cause, though.
You have to meet probable cause, but you don't have to get to the point as to actually looking at the...
It's not harmless error as it would be on a trial verdict or a guilty verdict. Is there still enough evidence in that to meet the standard of probable cause?
I think you have to adopt a rule or a ruling that if Harold Trebus materials are presented and there is exculpatory evidence in those Harold Trebus materials, and a prosecutor fails to even put the grand jury on notice of the existence of the Harold Trebus materials and at least meet the minimum standard of subject and outline of those materials, then it has not met its burden, period.
So
I don't
then-
think you
So we
get
Then
throw
we
out-
don't go on to do
I
a
don't
harmless
think you
error
do.
review?
I do not believe you do, and the reason you don't get to harmless error review is because there is such the control of the grand jury, its independence is so important that if they are not even told what they're allowed to consider because a prosecutor has held it back, I think you don't even have to get to harmless error.
What is our statutory rule or textual support or case law, for that matter, for that
I think your
position?
support is the
I
fact.
mean, I know that our Supreme Court has applied harmless error review in this, so how could we now say that we shouldn't?
I think that it is enough of a violation. But even if you did, I think there's enough of a violation here This is a case where there
Okay,
has
so
been,
just a moment. So then we've moved to, there is no support for that proposition.
okay.
Is that, you concede
No,
that?
I believe that there is support. I believe the independence of the grand jury would allow you to stop.
But I asked for either text rule or statute rule or case law that says we should.
I think it goes back to simply the independence of the grand jury. And I think if you have materials that needed to be, subject and outline needed to be provided, and that basis failed, I don't know how that could not be harmless error.
Okay, so
or
the
how that
answer
could
is
be
no,
harmless error.
there's no legal support, legal authority for that proposition.
I think the proposition is, I don't think that there is a specific statute, and I'm not trying to be obtuse. I don't think that there's a case or a statute or a rule that specifically says disregard harmless error. I think, but as applied in this case, the mere fact that there was, we know that there was specificity in the documentation provided, which is one of the ways in which cases have been found to be harmless error. There's specificity here, which there normally is as often. That was the failure in Black, and that was the failure in one of the, in Harrell.
And
that there
Trebus,
was-
too.
In Trebus, and there wasn't specificity. We know there's specificity. We know there was a specific request that the prosecutor present this information. Right at the top in big bold letters is, this is for grand jury presentation. There were confirmatory emails. So I think the idea is if you get into harmless error, I think you have enough bullet points of ways in which this presentation failed that you don't have to get into the mechanics of specific factual allegations in the Harold Trebus letter itself.
But counsel, couldn't we say that the state, in fact, in this case, presented enough evidence to meet that probable cause threshold? And that, in fact, your client's letter did not respond to some of the incriminating evidence that was presented?
Well, to be fair, we were operating blind as the search warrant was returned, or search warrant affidavit was only provided to us two or 3 days before the grand jury presentation, so we could respond to what was in the search warrant.
Sure,
And so
understood.
we really had to operate somewhat blind. But second of all, it's not a matter of meeting the probable cause. Most prosecutors can go into a presentation without defense intervention and meet probable cause. It's the other side of this, which is the defense's information may back a grand jury off of that probable cause, such as in Crimmins, where there was the crime prevention exception. That would have potentially, had it been presented that he was using citizen's arrest power, it could have backed them off of that probable cause. And that's for the recognition that the defendant must be able to present a substantive information to a grand jury to ensure a fair proceeding. And in this case,
But we can't go too far because it is just a preliminary proceeding.
well,
We're not going to send, okay, we get an indictment and then we refer it to the defendant and say, okay, now you put anything in there we'll go back to the grand jury. I mean, that's what the petite jury's for.
the complete adjudication of the case would happen in front of a petite jury. But this is a case specifically where very specific items that were well within exculpatory bounds were presented. And because they didn't even know that they had a defendant out there who was participating in a defense, that they made a decision without the benefit of that. And what Trebus says, what Just specifically says, is you can't summarize from an agent's point of view and treat that as a fair proceeding.
You have about 3 minutes left.
Yeah, I have 3 minutes. May I reserve?
Please.
Thank you.
I said I wouldn't police it for you, but I thought.
I appreciate that. Thank you, Judge.
I'll announce. Brett Haramis, representing the state of Arizona. Good afternoon. A real party in interest, Judge Garcia from the trial court.
Make sure you pull the mic down so
Oh,
it's
sorry.
picking it up well.
I apologize. Let's move over here. Okay, I think I'll start with some items that were written by the defense in his reply brief, specifically addressing the statements regarding the Bashir holding as well as the Black v. Coker holding. I think there is a distinction that is articulated in both the Bashir v. Pineda holding and Black v. Coker in the sense that there's a difference between the request to appear before the grand jury from a target of the investigation, as opposed to a request that certain information be presented at a grand jury concerning the target of the investigation, where there has been a unequivocal, in this case, unequivocal statement that the target would not be appearing to testify. And the reason for that is, I think, expressed in Bashir v. Pineda when they expressly differentiate between those two situations.
Well, as much as I respect prior decisions of this court, doesn't Trabus tell us otherwise, though, that you have to inform the grand jury of the defendant's request to testify or present evidence?
Yes, I think there is some.
So even if Black and Bashir may be read to say that there's a distinction between those two requests, how do I disagree with Trabus?
Well, I would say that the two situations are distinct, number one. And in Bashir, when they make that differentiation, when they have that, when they synthesize or address that differentiation, the court actually states that in the event that there's no testimony that is requested or no testimony that is requested by the target of the investigation, it opens up a wider view. It requires the prosecutor to take a wider view of the evidence. Now, it says that, and in that wider view, the prosecutor may be required, due to the request of that certain information be presented, to make the grand jury aware of those facts. However, it does.
Even Mr. Hermes, this is what they said in Trabus. I am going to echo what Judge Morris just asked you. We hold the county attorney must inform the grand jury the defendant has requested to appear or has submitted exculpatory evidence. Did you ever say to this grand jury, the defense has submitted exculpatory evidence?
No, I did not. However, in the presentation by the state or by myself, we did address each and every factual assertion within that Harold Tribus letter presented by the defense. So, in a sense, I understand your perspective I never said that they presented exculpatory evidence. However, in the testimony.
Did you say present evidence, or there's some evidence here that's been presented or provided by defense?
Yes. On several occasions, the actual citations, I believe, are in my response petition.
So you let the grand jury know some of this evidence came from the defense, but you never called it exculpatory evidence?
Yes, that's a distinction.
Nor
Yes.
did you give an opportunity to read the letter. You didn't give them the opportunity to read the letter.
Correct. That's correct.
And I'm not sure why. If you presented everything that's contained within the letter, why wouldn't you just say, oh, and by the way, there's a letter if you want to read it?
In reviewing the Harold and Tribus letter, there are certain assertions within the letter that simply aren't relevant to the proceeding and the probable cause determination.
Okay, what was that?
That would be the first page and second page of the letter. There are several assertions in terms of what was disclosed by the state to the defense, in terms of whether there's negotiations taking place or whether they've been cut off by the state. As I put in my motion,
Well, that's a fair point, and let me ask you a follow-up. So if you had gotten the letter and there was a big paragraph in the letter that you thought was clearly not admissible, I mean, it wasn't, we'll go with the rape
Relevant
shield.
or-
Relevant. It's the rape shield provision of
Okay.
my hypothetical accounts. Couldn't you just, say, okay, we have a letter here and we're just going to redact that one paragraph out? Because the other evidence the other things contained in the letter may actually fit the definition of the Tribus requirement.
yes, that's a possibility.
So
Of
why
course.
couldn't you just do that in this case?
I think I did not do that in this case. The reasons for not doing that is, in my estimation, we presented a case that was fair and impartial, and it actually took into account all the factual assertions from the defense in the Harold and Tribus letter. If we go through the transcript of the presentation, we elicit, or the state elicits evidence that the suspect, Mr. Trinh, actually did tell the father of that minor patient that he was not a medical doctor. Also, the family of that minor patient met with Dr. Kawamoto, a licensed medical doctor, both times that the motor threshold determination was done or performed in a diagnosis of their minor child. There is no evidence that presented that Mr. Trinh engaged in any diagnosis of the minor patient. Each time that diagnosis took place, Kawamoto was present. There's evidence presented that Kawamoto signed off on each and every medical decision within the records, manifest in writing at Lighthouse Psychiatry. We presented evidence that the mother was a layperson and the father was a layperson when it came to medical experience or medical expertise. And in the interview with the defendant that was presented via the agent who testified, the defendant himself denied engaging in any diagnosis or determinations that required a medical license with respect to that minor patient. Also, Dr. Kawamoto was the original doctor who referred that minor patient to Lighthouse Psychiatry.
So, counsel, is it your position that as long as the state, in the state's estimation, the evidence that the defendant wishes to present has already been covered by the state, then there is no need to advise the grand jury that the defendant wishes to present evidence?
It depends, but largely yes. Largely yes. I don't see if the testimony.
How do you reconcile that with Trevis that says the grand jury is to decide if it wishes to hear a defendant or his evidence? How can you decide that for the grand jury?
What is contemplated in the case law that's cited in the pleadings to this litigation is there's a lot of talk about an outline or giving the grand jurors the opportunity to determine whether or not they want to receive the information that's been submitted. So in satisfying whether or not in satisfying that outline requirement that is, I believe, explicit on the case law that we've cited, both sides, in the state's estimation, when the information is presented in and of itself and attributed to the defendant within the context of the testimony and the presentation to the grand jury, that outline requirement has been satisfied because.
But you missed the point. The point of an outline is to then tell the grand jurors or take the next step, which is, now, do you want to hear it or not? And the outline you would say, this is what has been outlined, and it's in the form of a letter, or it's in the form of, he wants to testify. Do you want to hear it? And then it's the grand jurors that get to decide.
I guess from the state's perspective, then, the presentation of those facts within the Harold Trevis letter, in and of itself, the court feels is not a sufficient satisfaction of the Trevis requirement. I believe
it's whether the grand jurors get to make that call, isn't it?
Right. However, if we're talking about the language in the Bashir or Trevis, or when a request that evidence is submitted, it requires the prosecutor to take a wider view of all available evidence. That implies to me that there's still a question about whether or not to present that evidence beyond an outline. And
let me just read you what just says. The grand jury may either grant or deny the request. The statute does not authorize the prosecutor to present a third option of summarizing the defense evidence from its own point of view. Isn't that exactly what you did in this case?
I don't think it was when looking at the facts of just, yes, you could make that argument. I guess my response to that would be that in the just case, the summarizing was a tape recording subject to a court order that happened prior to that presentation. And it was, in the language of that decision in the just case, that was a misleading and claimed perjured testimony based on that summary of the recording. So here, when we're talking about whether it's the impeachment evidence of Shannon Harris, which was requested in the Harold Tribus letter, which the state presented, or it's the number of, excuse me, or it's the fact that there is no evidence that in writing that the defendant or the suspect had treated that minor patient. That was presented. The fact that he had never signed off on any medical records within Lighthouse.
Yeah, that's why I grimace, because I heard your argument different than what you just responded to Judge McMurdy. I heard your argument being, and read it in your briefs, is you didn't summarize the evidence. You actually presented the evidence.
Yes, that's exactly right.
By the defense.
I'm saying.
And so I read the issue as, was it error for you to present that evidence without crediting the defense more fully, as opposed to, or at least your position is, did we err in not crediting the defense more fully because we presented the evidence they asked us to present?
Precisely, yes. And what I was getting at with the just language that was.
But you presented it from your point of view. I mean, that's what Just says you can't do, and that's why I asked the question, if that's what isn't what you did.
Well, so it wouldn't matter if the state would have read verbatim from the letter or presented the evidence exactly through testimony.
It wouldn't matter, then why are we here? You could have just presented it.
Right. So I guess my argument in the pleadings is that the material, for all intents and purposes, within that Harold Tribus letter was presented to the grand jurors. Whether or not they wanted to refuse that information, yes, I think I presented that evidence without asking them if they wanted to receive it. However, that is all evidence that's beneficial to the defendant in this case. That's evidence that was presented, which the state did not have to present in terms of the impeachment of Shannon Harris, which was.
Just a moment.
Yes.
So if you're giving a presentation as coming from the state, you're saying that the grand jury could say, no, we don't want to hear that portion, not knowing that it's being offered by the defense. It's a part from the defense that you've incorporated into the state's presentation, and the grand jury is free to say, this portion you're testifying to, we don't want to hear that. Is that what I'm hearing?
No, I guess it's a bit more specific to this presentation in the sense that the investigator testified that Mr. Trinh was certified in those classes sponsored by the Harvard Medical School. Mr. Trinh did.
What I don't understand is how does the grand jury know this is the defense's evidence and we have the right to reject it? They wouldn't know.
I guess from my perspective, it would be, and I apologize if this is not directly answering your question. In my estimation, when there is a letter and a request to present evidence that is in any way exculpatory, at least from the state's perspective, that needs to be produced or presented through testimony or otherwise.
All right, so then you're narrowing it to exculpatory evidence, not just defendant's evidence.
Well, exculpatory evidence and whether it's impeachment, any evidence, I suppose, in my thinking, any evidence that would tend to be beneficial to the defendant as requested.
Doesn't Trivas just say that you need to let the grand jury know when the defendant wants to testify or present evidence, period? It doesn't characterize it as exculpatory evidence or in any other way.
Yeah, but I believe that in Bashir and probably just Bashir, I know, that when there is a request, not a request to testify, but a request to that evidence be shared with the grand jurors from the defendant, there is a distinction where there's a wider view of the evidence that's submitted by the defendant that needs to be engaged in by the prosecutor. And whether that wider view determines whether items or facts are irrelevant or not, it opens the door, for instance, factual inconsistencies and witness credibility in that latter situation where there's no request to testify, but there is a letter that's submitted with evidence. Those two areas are expressly held as still not relevant to the grand jury presentation under Bashir. And it's a wider view of the facts. However, that does not compel factual inconsistencies or witness credibility information, or doesn't require that from being presented to the grand jury. However, in this case, it was because it was in the letter and I presented it. Not the letter, but the testimony.
And then to follow up on the question Judge McBurney asked earlier, so in terms of the Just case, in your estimation, since your presentation was not misleading, in that Just case, there was misleading and perjured summary, right? And since that wasn't the case, then there is no requirement that the grand jurors be alerted, correct? Because you gave a fair presentation of what the defendant wanted to present.
Yes, yes. However, if we're talking about the Just case, the harmless error analysis, I think, actually further buttresses the state's position in this case, in the sense that there was perjured testimony, there was a court order involved that demanded the prosecutor present the evidence in a certain way. That wasn't done. There was an actual summary that was objectively untrue or misleading or dishonest. And despite that, the court still found harmless error given the rest of the facts of the Just case. So I think in sum, the Just case helps the state's position that even if the court finds that I or the state erred in not submitting the letter to the grand jurors, it is harmless error given the other facts.
That's not the test. The test is whether or not you just advised them of it, right? It's not that you didn't submit it. The test is that you just didn't tell them about it.
Correct. And I think I suppose the state's response to that would be that in the exchange between the state and the witness in the presentation, it's the state's position that all of those facts that were articulated in the Harrell and Tribus letter was disclosed to the grand jurors.
Which, in your opinion, would go to the harmless error analysis.
Yes. So I believe that in this case, yes, there was no letter that was presented, and again, as Meritech's been cited a few times, there's no mechanical test. All of these myriad variables are existent from case to case. This case has a number of different variables, and in the trial court, despite the fact that the ruling may have been somewhat based on the incorrect standard, the trial court did hold that there was a fair presentation and found that the presentation was permissible and not a violation of the defendant's due process rights in that regard. So.
I have one last question, I promise. Was there anything in the letter that you found to be objectionable?
Yes. In terms of the impeachment evidence, I thought that I probably had grounds to object to that. However, even though I had the grounds to object to it, I presented it anyhow.
You also mentioned earlier the lack of disclosure issue and the failure to engage in negotiations with you as well.
And I didn't present that portion, but yes, I did.
Would you
reference
say that was objectionable?
Yes. Yeah, but in terms of the facts that were submitted, there's no meaningful difference between the transcript and the letter itself when viewing the presentation in its totality, in the sense that most of the facts that were outlined or articulated in the Harold Trebus letter submitted by the defense was attributed to the defendant during the transcript. I'm off.
Thank you, Mr. Ramos. Mr. Carey?
Yes, two brief points. One is Just is very clear that it's the grand jury's role to either grant or deny the request.
Let me ask you a question. Under Trebus, you have to tell them that the defendant wants to testify or present evidence.
Correct.
Is your letter evidence?
I think the items, the bullet points in there
So you would agree with me, the letter itself is not evidence.
I think the letter is a characterization, and it specifically indicates in Bashir that a grand jury's decision will often depend on being adequately informed of the circumstances surrounding an incident, including the defendant's version of events.
So if let's say the state had would you agree, like, the discussion at the beginning about
Yeah,
characterization?
absolutely.
Didn't have to read that to the state?
Exactly,
And your final paragraph where you say there's not probable cause, your summation, you
Argument.
wouldn't have to read that to them?
I agree with that.
Okay. So if the state had read everything between the first page and that last paragraph, but not attributed it to you, would we have any error at all?
You would absolutely have an error, and the reason is that just specifically says you cannot use an investigator's point of view.
No, that's what I'm saying. He had read it word for word as you wrote it, but just didn't say, and now I'm reading to you a letter from defense attorney.
Still an error. I think there's something very...
What's the error?
The error is that when a defendant comes forward to actually indicate that they want to challenge or they want to be heard, you have to give that deference. The grand jury needs to know that a defendant has come forward with this information because it is qualitatively different than it being weaved into the discussions by the prosecutor. They stand as the
But they
state.
presented every bit of evidence that you
They
wanted them to.
stand as the state, though, and there is a certain mantle that's carried with it when a state is reading something, compared to when they know that the opposition, the person who is the target, has come forward with specific information. I don't think that it allows
So,
it.
so Mingus, if the, I'm sorry.
No, go ahead.
So if the state doesn't say, there's no preamble, it just launches into reading the letter, it's your position that's error.
That would still
But-
be. Oh, please.
Oh, I get to finish. If the state does give a preamble and say, the defendant, what wishes you me to read the following, then there's no error.
I think there would not be error in that case if it
Oh,
was
boy,
attributed to the
isn't
defendant.
that a fine line to determine beyond a reasonable doubt on that issue? Isn't there, Mr. Carrick?
I don't. The statute makes it very.
Doesn't our Constitution say we shouldn't reverse for technical error?
I don't think it's a technical error. The statute specifically says that it's the defendant who, if the defendant may present evidence and the grand jury gets to decide if they hear it or not.
Is it because somehow it's implied that the defendant is admitting or acknowledging or adopting part of what, of that testimony as opposed to this is what the state is alleging? It's the defendant saying, this is my version of the fact?
That's correct. It goes to defendant's version of events, paragraph 11 of Bashir, that specifically talks about the fact that it's the defendant's version. There's something that
Finish the
attributing it
sentence or thought.
to the defendant. I did have one closing issue on the harmless error since it came up, if that would be granted a moment
I think
on
we've
that.
heard enough. Okay. Thank you very much for your presentation today. We will take this matter under advisement and issue a written decision in due course.